Testing 1 2 3, testing 1 2 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode, RFM's Wide World of Courts, a Jenn Kamp Rosebud update. Well, a number of things have been happening on the Jenn Kamp front with the civil suit in Utah between her and John DeLynn and the Open Stories Foundation. I want to update you on that. Also, I have an update for you about Rosebud's bar complaint against me, because even though it has been dismissed, even after she asked for the original dismissal to be reviewed, that was dismissed. Apparently, she just can't stop. She still has more she wants to say to the Bar Association, not only what she thinks about me, but what she thinks about them now as well. We'll get to that in the second part of today's podcast. But first up is Jenn Kamp. Now, you remember that the situation and the status of things with the civil suit between her and John DeLynn and OSF in Utah is the following. OSF and John DeLynn, as the plaintiffs in the case, had filed a lawsuit against Jenn Kamp alleging that she had committed defamation against John DeLynn and OSF by making scurrilous accusations against John DeLynn in her podcast as well as in other venues. What happened was that never got to trial, and it will never get to trial because Jenn Kamp, instead of abiding by the discovery process by which parties exchange information in preparation for trial, she was busy hiding the evidence that the Open Stories Foundation and John DeLynn needed to prove that she had committed defamation. So she's hiding all this information and deleting it, and all this information obviously shows that she had been defaming John DeLynn and OSF. So what the judge did in that case, Judge Robert Faust, is he said, I'm going to find as a matter of fact and as a matter of law that because you have been busy hiding all this information and all this evidence, Jenn Kamp, you have deprived the plaintiffs of their ability to even have a fair trial in the matter. And therefore, the judge found Jenn Kamp to have committed defamation as a matter of law and as a matter of fact. That means there's going to be no jury trial on the issue. She has already been found by the judge, because of her reprehensible behavior in hiding evidence, to have committed defamation. The only thing left is to have a hearing in August, not about whether she committed defamation, because that's already been decided, but about how much she's going to have to pay John DeLynn and OSF for the defamation that she has already been found to have committed. So that's going to be in the nature of a damages hearing. We know that an order has already been entered ordering Jenn Kamp to pay $12,000, I think it was, in attorney's fees to the plaintiffs. And I believe another order of a similar nature in the neighborhood of $60,000 or so is coming down the pike. So just in attorney's fees alone, I believe that Jenn Kamp is going to have to pay at least $70,000 to John DeLynn and the OSF. And the basis for those large amounts of attorney's fees is that this is the work that John DeLynn and OSF's attorneys had to do in order to try and get the evidence from Jenn Kamp that they would not have otherwise had to do if she had been playing by the rules and not playing dirty. So because this was work that the plaintiff's attorneys had to do, not because of anything the plaintiffs did, but only because of the wrong conduct and the bad behavior of the defendant, Jenn Kamp, she was ordered to pay the attorney's fees for that. So she already owes John DeLynn and OSF over $70,000, I believe, and that's going to be in addition to whatever damages the judge determines that she is going to owe the plaintiffs at the hearing in August. So in the meantime, it appears that behind the scenes, Jenn Kamp has been engaged in a series of transactions, two significant ones that I'll point out to you today, which look like they could be designed to make it so that as of the time the judgment is entered in August, Jenn Kamp will be poor as a church mouse and not have any money to go after to satisfy the judgment, and have no assets to go after in order to satisfy the judgment. How is she doing this? Two things. First is she quit-claimed her interest in the family home to her husband, Jason Kamp. That was on May 7th, 2024. And second, a month later, on June 11th, 2024, she filed for divorce against her husband, Jason Kamp. Let's look at those documents, shall we? The first document is a docket from the 3rd Judicial District Court. Now, this docket has to do with one case and one case only. And as you can see in the upper left-hand corner, the case has a number and it is a divorce/annulment case. To the right, you can see that the current assigned judge is Mark Curris and the parties are below that. The respondent in the case is Jason Paul Kamp. The petitioner in the case is Jennifer Ruth Kamp, which means that Jenn Kamp filed for divorce against her husband, Jason Kamp. If you look under description, you can see that the petition for divorce is private, as well as a stipulation for divorce, as well as vital statistics for the divorce, all labeled private. But this petition was filed on June 11th, 2024. You can see that if you go over to the right, and you will notice the date there under filing date. This petition was filed on June 11th, 2024. Not every document in this divorce, however, is private. There are some that are rather standard and boilerplate kinds of filings that are not private. And I obtained one of those as well, which I'll show you here on the screen. And here is the document that is titled a Domestic Relations Injunction. Once again, this is a rather boilerplate kind of document that gets filed at the inception of every divorce. It basically tells the parties to the divorce that they have to maintain the status quo going forward. And there's not going to be any funny business like emptying bank accounts, for instance, after the petition is filed. That's what this order seeks to prohibit, among other things. But there you can see the date it was filed was June 11th, 2024 at 10 o'clock in the morning. And you can see very plainly the title of the divorce. In the matter of the marriage of Jennifer Ruth Kamp, petitioner, she's the petitioner, she filed for divorce against her husband, Jason Paul Kamp, who you can see is the respondent in this matter. Now, some of you may be wondering if there really is trouble in paradise and if this filing for divorce really signals an irretrievably broken relationship between Jenn Kamp and her husband. Or might it be something else? Might this be a sham divorce on paper in order to accomplish a different objective? Well, let's look at what Jenn Kamp was doing the month prior when she signed and filed a quitclaim deed on the house, giving all of her interest in the house to her husband, Jason. This is very unusual that we would see Jenn Kamp giving all of her interest in the house, which is probably the primary family asset, to her husband the month before she files for divorce against her husband. This is looking very peculiar indeed, but let's check out the document that shows the quitclaim deed, shall we? And here is that document. You will notice it is titled Quitclaim Deed from Jennifer R. Kamp of Taylorsville County of Salt Lake, State of Utah. I redacted the actual street address above, but the family home is in Taylorsville, and it is from Jennifer R. Kamp to Jason P. Kamp, her husband, of Taylorsville, County of Salt Lake, State of Utah, for the sum of $10 and other good and valuable consideration, the following tract of land in Salt Lake County, State of Utah, to wit. And then it says, see attached Exhibit A, where it gives the legal description of the property on which the family home is situated. And there's the tax ID number. Witness the hand of said grantor the 7th day of May, 2024. And there you can see it's signed by Jennifer Kamp. It is notarized. And on page 2, there is the legal description of the tract of land. So what does this mean? Well, first off, it means that on May 7th, 2024, Jenn Kamp gave all of her interest in the family home, probably the primary asset that Jenn Kamp has, to her husband, Jason Kamp. And then the following month, Jenn Kamp files for divorce against her husband, Jason Kamp. This has all the earmarks of a person who is trying to divest themselves of every asset they possibly have. In this case, it's one. In most families, it's one, the family home. And this frequently happens in the context of a lawsuit where the person who's trying to divest themselves of all of their property and all of their assets is the one who's the defendant in a civil suit. What it's starting to look like is that Jenn Kamp is very concerned about the prospect that a huge judgment is going to be entered against her in favor of John DeLynn and the Open Stories Foundation, bigger even than the $70,000+ that she's already going to be ordered to pay in legal fees alone. It's only going to go up from there. So this looks like she's trying to divest herself of her assets. First off, by quitclaiming any interest she has in the family home to her husband in May, and then the following month, she's going to divorce him, or at least file for divorce, so that she can get more distance between herself and this property, i.e., the family home, so that John Dehlin and OSF will not be able to go after the family home in order to satisfy the judgment, which will be entered in August of this year. Now, fortunately for John Dehlin and OSF, and unfortunately for Jenn Kamp, there is in the state of Utah a fraudulent transfer act, which is designed specifically to reverse and avoid this kind of skullduggery on the part of defendants in civil suits, as well as other types of suits. But no, it seems unlikely that this type of shenanigan will be countenanced by the court. And in fact, it is my understanding that OSF and John Dehlin's attorneys have filed a motion for a temporary restraining order, another restraining order. This restraining order being restraints be put in place to prevent the sale of the home. Now, the third thing that you should know is that after quitclaiming her interest in the property to her husband, and then after filing for divorce against her husband, they put the house on the market. The house is on the market. I think it might even be under contract now. So what OSF and John Dehlin's attorneys have done is filed a motion to put the stop to this, put the kibosh on this deal, and prevent Jenn Kamp from getting away with this rather obvious ploy. That motion that's been filed is set for hearing this coming Monday, July 8th, 2024. By the way, for the record, I am recording this on the morning of July 4th, 2024. So happy Independence Day to all of my listeners here in the United States. I have worn my Captain America t-shirt in honor of the occasion. So this coming Monday, July 8th, 2024, there is scheduled for hearing a motion by John Dehlin and OSF's attorneys to put the kibosh on this deal, to either prevent the house from being sold, to put a lis pendens or a lien on the house, or to have some kind of order entered that any funds that are obtained through this sale of the house be put into some kind of trust account over which Jenn Kamp and her husband do not have control, pending the outcome of this case and finding out how much it is that Jenn Kamp is going to owe Open Stories and John Dehlin for her defamation of them, in addition to the attorney's fees. We'll see how that hearing goes. I imagine that this is not the first time that Judge Faust has encountered a defendant who is engaged in this particular kind of ploy. It's not that unusual, believe me. So that's about enough for Jenn Kamp. Let's get to the update on Rosebud, aka Anne McMullin Pfeffer. I thought this story was over with. You remember that she had filed a bar complaint against me. It was denied, and then she asked for a review of that decision, which review was held by a panel of 3 members of the Washington State Bar Association, and on a vote of 3-0, they dismissed her complaint. Here's a copy of that document, which I showed to you the last time I podcasted about this issue. Once again, this is the Review Committee order of dismissal, showing that the order is the Review Committee affirms disciplinary counsel's dismissal of this grievance with no further action. This order is not, repeat, not appealable. It's dated the 22nd day of May, 2024, but it was emailed on June 3rd, 2024. And that will be important because Rosebud will swing into action again between these two dates, still thinking that she has an opening to file additional information against me, which she is sure will sway the Bar Association's mind in her favor. And there's the email date of June 3rd, 2024. The vote was 3-0 in favor of affirming the dismissal of the grievance against me. Yes, RFM 3, Rosebud 0. So let's look at what it is that Anne McMullin Pfeffer, aka Rosebud, filed with the Bar Association between those two dates. Once again, she's using the standard grievance against a lawyer template, which is provided by the Bar Association, but you'll see that the date is May 28th, 2024. So that's in between the May 22nd date when the order was decided dismissing her appeal and the date on June 3rd when that dismissal order was actually emailed out to Anne as well as to me. And here's what Anne has to say in this. On April 9th, 2024, I received a letter from Ms. Lewis stating that this matter has been referred to the review committee. See, she's not aware it's already been dismissed because she hasn't been notified. I have since gained new information that is material to this case. Oh, I'll bet it's material. A letter signed under the penalty of perjury from myself and a November 30th, 2023 deposition in a case that I am not party to and that personally mentions both myself and Mr. RFM are attached. And here she attaches not only links to those documents, but she also attaches the documents themselves to this grievance supplement. So let's look at her declaration first, shall we? Let's scroll down here. Here it is, May 28th, 2024. Dear Ms. Lewis, writes Anne Pfeffer, thank you for your letter dated April 9th, 2024, stating that you have referred this matter to the review committee. I have since discovered that Mr. RFM is representing Mr. John DeLynn, the ex-Mormon podcaster, legally, and have gained access to a deposition in a Utah case that mentions me personally. Let me clarify for the record once again that I do not represent Mr. John DeLynn in any case. I have never represented him in any case. I have not received any money from John DeLynn to represent him in any case. The truth of the matter is that he has reached out to me on occasion asking for legal advice relating to this matter, which I have shared with him. There has been no money that has exchanged hands. I am not John DeLynn's attorney in the lawsuit. However, the fact that he has reached out to me for legal advice and I have given it to him does create an attorney-client relationship, which means that the substance of those communications are private. They are protected by the attorney-client privilege, even though no money has exchanged hands. Money does not have to be paid. I know it's a joke, right? That you say, I'll give you $1, so now we've got an attorney-client relationship. Yeah, it's a joke. Money does not have to be exchanged in order for an attorney-client relationship to be formed. Literally hundreds of people over my 34-year career in practicing law have reached out to me for legal advice. Some I know, some call on the phone. Some of those people will pick up as clients and they will retain me, and I will enter a notice of appearance on their behalf in whatever case it is that they happen to have going. But for all the people that I talk to who don't end up retaining me, I still have created an attorney-client relationship with them because they have told me confidential stuff on the phone. I have given them legal advice. The same thing happens here with John DeLynn. I am not his attorney. He has never retained me. He has never paid me any money. And yet there is an attorney-client privilege as to the communications that he and I have shared regarding his case. And goes on. The deposition is for case number so-and-so in the 3rd Judicial Court in Salt Lake County, Utah. Yes, this is a deposition, apparently, that John DeLynn went under as part of his civil suit against Jenn Kamp in Utah. Her attorneys, she had attorneys at the time back in November of last year. Her attorneys deposed John DeLynn. It was probably a multi-hour affair. They generally are with important witnesses, such as a party would be. And it ends up being 365 pages long. And Anne McMullin Pfeffer, bless her heart, attaches the entirety of the deposition. In addition to this particular statement, I personally received an electronic copy, she writes, of the deposition from Ms. Jenn Kamp, party to the case, in early April 2024. And there I'm sure that Anne wants to make it very clear that Jenn Kamp did not give her a copy of the deposition after the court ruled that she couldn't be defaming John DeLynn anymore in entering that initial restraining order against her. For clarity, I am personally mentioned in the deposition, and Mr. John DeLynn's sexual harassment of me is a topic of that case. Well, it's a topic of that case only because Jenn Kamp's attorney brought it up during the deposition. It has absolutely nothing to do with the case between John DeLynn and Jenn Kamp. Sorry to break it to you, Anne, you're just not that important. She goes on, but I am not myself party to the case. That's correct. The public interest in these matters has drawn me in. Oh, yes, so much public interest, so much drawing in, Anne. The deposition I would like to add to the evidences provided to your bar association in this matter is the November 30th, 2023 deposition of Mr. DeLynn. As you consider Mr. RFM's ethical conduct, well, I'm glad she's admitting it's ethical. She might have meant to write unethical, but I like it the way it stands. As you consider Mr. RFM's ethical conduct, you should have Mr. DeLynn's deposition alongside my forensic interview and the documents available at the Rosebud Wiki offered to you in my previous correspondence. Yeah, that's going to make things really clear. Why don't you just tell them what it is that's important for them to know instead of trying to offer them and get them to read hundreds of pages of documents and listen to hours and hours of you talking? See Mr. DeLynn's November 30th, 2023 deposition, and then she gives some references in the deposition for evidence that he has retained Mr. RFM, a fact I did not know when I made my previous complaint. Which raises the question, Anne, if you had this deposition, as you say, as early as early April 2024, Why is it that you did not know that fact when you made your previous complaints against? That's the question that the Bar Association would have for you. That is, if what you were saying had any relevance whatsoever. She goes on, Mr. RFM's podcasts about me support Mr. DeLynn as a high power sexual harasser who is willing to perjure himself in his endeavors to ensure that others who might dare to speak out against him publicly are too afraid to break their silence. Mr. RFM's support of his client go beyond standard publicity and rise to the level of complicity in Mr. DeLynn's perjury and defamations. The objective, it appears, is to run smear campaigns to terrify those who would speak out against Mr. DeLynn into silence, even though Mr. DeLynn's public persona is one of a man who believes in transparency and supporting victims in gaining voice. Now, you can see there at the bottom that this is an 8-page document. This is only page 1 of 8. Now, what Anne is going to do is she is going to spend the next 5 or 6 pages, in other words, the bulk of this declaration that she sent into the bar, talking not about me, but talking about John DeLynn and making all manner of defamatory statements against John DeLynn. Now, I think it's just possible that Anne may be clever enough to think, well, if I write it down in my complaint and my grievance against RFM to the Bar Association, I know that he's going to read it on the air and thereby help me get out my message of my defamatory statements against John DeLynn. Well, if Anne is thinking that, she is going to be disappointed because I'm not going to read this whole thing. I'm just going to read the stuff that has to do with me. So we'll skip the next 5 pages and pick up the statement again when she gets around to mentioning me once more. She alleges here at the top of page 7 about John DeLynn that he spent years defaming me in order to, I assume, publicly and permanently link me to him in history in a way that shames me rather than legitimizes the good work I did for ex-Mormons while in his employment. This is absolutely delusional on your part, Anne, that you assume that John DeLynn has spent years defaming you. He hasn't been defaming you. You've been defaming him. You got it a bit backwards there. And that he's doing it in a way to link you and him together in history forever, permanently? Really? Is that what you think John's doing? Because it really looks like, from this perspective, that that's what you're doing. So you can imagine how delusional and defamatory the prior 5 pages have been, the 5 pages that I am mercifully skipping and going down to the point where she talks about me once more. She says about herself, I was a very productive and successful employee, despite the difficulties of dealing with Mr. DeLynn's harassment and abuses. And Mr. RFM, see, she finally does get back to me. And Mr. RFM's podcasting has supported Mr. DeLynn in these retaliatory endeavors. But as I stated in my previous communications, I am most concerned about Mr. DeLynn's facade as a media presence who wants to expose child sexual abuse in Mormonism while he is simultaneously podcasting against the credibility of victims of organized child sexual abuse. And then she gives a helpful link to a webpage that apparently is called Organized Abuse. Worst of all, the timing of his podcasts regarding satanic ritual abuse, a red herring that protects offenders and discredits victims of organized abuse, have aligned with important dates in an important court case in Utah that mentioned satanic ritual abuse as part of the defense's efforts to discredit the plaintiffs who claimed they were victims of organized child sexual abuse. And here she gives the name of a case. It is possible that the Does versus Miles case that she referenced above might have exposed Mormon leaders allegedly involved in organized child sexual abuse if the case had not been dismissed when the Utah Supreme Court decided not to allow the Utah legislature to extend the statute of limitations for victims of child sexual abuse in another case, Mitchell versus Roberts. It seems Mr. DeLynn was preparing his podcast listeners to discredit the plaintiffs if the case had moved forward. Can you say delusional? I knew you could. The matter of organized child sexual abuse, she goes on, is of extreme importance, and it appears that both the Mormon Church and Mr. DeLynn, who publicly professes himself to be against the Mormon Church and for the exposure of abuse, are involved in misleading the public about extreme harms that come to Utah children. So This apparent war between John Dehlin and the Mormon Church is just an illusion. Actually, behind the scenes, they have joined hands and they are engaged in a joint effort to try and permit church leaders to sexually abuse children in a satanic and ritualistic way. Yeah, that sounds totally non-delusional to me. Mr. RFM's podcasted smear campaigns of individuals who attempt to stand up to Mr. Dehlin support these cover-ups. So my podcasts are supporting the delusion that John and the Mormon Church are engaged in an effort to allow Mormon church leaders to satanically sexually abuse children. Got it. I do not have the resources to sue Mr. RFM or Mr. Dehlin because I don't assume I could withstand Mr. Dehlin's propensity for perjury, his aggressive legal tactics, the financial support for legal fees he has from donors who believe he actually does support women and really is trying to expose all abuses in the Mormon Church. The public support he gets from his podcast following in online comments and the smear campaign Mr. RFM would engage in against me on YouTube if I tried. Mr. RFM has engaged in a highly aggressive campaign against Jenn Kamp, another former female employee alleging Mr. Dehlin's sexual harassment, who has also made a bar complaint against Mr. RFM. Can I just respond to this for a second? I am not engaged in any kind of campaign against Jenn Kamp, aggressive, highly aggressive, or otherwise. All I am doing is showing the publicly available evidence related to the case that she has with John Dehlin. And unfortunately for Jenn Kamp, the evidence that is publicly available shows that she has been making statements since the end of 2022 that are demonstrably not true, that are demonstrably in conflict with the hard evidence. That's what's been going on, not any kind of a smear campaign against Jenn Kamp. Jenn Kamp is smearing herself, and the evidence that I've been providing prove it. To date, Mr. RFM has published somewhere around 10 podcasts smearing Ms. Kamp regarding her allegations against Mr. Dehlin. As far as I can tell, Mr. RFM is even still pretending Ms. Kamp sued Mr. Dehlin rather than vice versa. I don't know why she puts this in here. Jenn Kamp did sue John Dehlin initially. She sued him by filing a case against him in the wrong court. She filed it in federal court. When she filed that, she was not represented by attorneys at the time. Presumably, attorneys would have known that federal court was the wrong court system to file this kind of a case in, and that the correct court was in the state court of Utah. Then, because Jenn Kamp would not shut up and stop making defamatory comments about John Dehlin publicly in her podcast and in other forums, John Dehlin and OSF felt that they had no other option left but to file a lawsuit against Jenn Kamp for defamation, which they did file in the correct court. As soon as Jenn Kamp found out that they were filing that lawsuit against her, which fact she found out when I actually did a podcast about the lawsuit that had been filed against her, she immediately turned around and on February 14th of 2023, in retaliation against John Dehlin for filing a lawsuit against her, she filed a baseless and groundless petition for an anti-stalking order against John Dehlin. Now, she got the temporary order. That happens as a matter of course. Judges hand those out like popcorn. But when it got to the actual hearing on the evidence and the facts related to her allegation, she lost because she had no evidence that John Dehlin had been stalking her. That's why I call it a baseless and groundless petition for an anti-stalking order, which Jenn Kamp filed against John Dehlin in retaliation for John Dehlin filing the lawsuit against her. So I'm actually not pretending anything, Anne, as you allege here, where you write, as far as I can tell, Mr. RFM is even still pretending Ms. Kamp sued Mr. Dehlin rather than vice versa. Actually, both are true. Mr. Dehlin and his organization are the plaintiffs in the matter, which is easily seen on the first page of the attached deposition. I am also highly aware that in Utah, judges rule in favor of male abusers and male harassers. Of course, because it's Utah, right? And again, that on June 11th, 2020, the Utah Supreme Court ruled in favor of not allowing for the Utah legislature's extension of the statute of limitations for child sexual abuse, which in effect also dismissed the Does versus Miles case, due to an August 2nd, 2019 decision in the Miles case filed by Judge Jill N. Parrish, which reads in its entirety, defendant's pending motion to dismiss and the plaintiff's ability to maintain their state law claims hinges entirely on the Utah Supreme Court's resolution of certified questions in Mitchell versus Roberts. The court will therefore stay this case pending the issuance of a decision in Mitchell. So what she's complaining about is that the statute of limitations for child sex abuse cases in Utah apparently was not extended. And I think the case that she was referring to previously was a case against a daughter of President Russell M. Nelson and her husband, and the allegations were against them. But this is alleged to have happened long, long ago. And therefore, the statute of limitations has long since expired. And therefore, what she's saying is that the charge against them or the case against them will be dismissed because the statute of limitations has expired and was not extended. She concludes, I testify under the penalty of perjury that all the above is true and correct according to the best of my knowledge. I am happy to testify. I am happy to testify under the penalty of perjury because I am telling the truth. Yeah, nothing says you're telling the truth like you saying, I'm telling the truth. And I hope that real perjury really does have a penalty because it is Mr. DeLynn who is guilty of it, not me. And Mr. DeLynn's position of high power means that his perjury affects many people, not the least of which is myself. Mr. RFM's decision to podcast about his bar complaints have brought you into this matter. No, I thought that your bar complaints had brought them into this matter, not my podcasting about it. But regardless, that's what she writes. Mr. RFM's decision to podcast about his bar complaints have brought you into this matter. I appreciate your attention to it. Best regards, Anne McMullin Pfeffer, signed May 28th, 2024. Now, once again, May 28th, 2024 was after the Bar Association had already denied her appeal, right? But she didn't know that yet, and neither did I. We didn't know it until it was emailed to us on June 3rd. So let's see what it is that Rosebud has to say once she receives a copy of that order. Someone's not going to be happy. And here we have what it is that Rosebud then submitted to the State Bar Association after she received the June 3rd, 2024 copy of their order denying her appeal. She once again uses the same template that's titled Grievance Against a Lawyer, but you'll see it's dated June 9th, 2024 at 3:30 in the morning. Wow, she was staying up late, burning the midnight oil on this one, huh, Anne? This is what she has to say. Dear Washington State Bar Association, I am writing to let you know that Mr. RFM again podcasted about my complaint under the new title, Rosebud's Bar Complaint Goes Up in Flames. And then she gives a link to the episode. His decision to do so was predictable, of course, and I, of course, fully understood that making my complaints opened me up to further publicity at his hands. Still, this shouldn't be occurring in the first place, which is why I contacted you. Again, I haven't watched his most recent Up in Flames podcast. I do not know if he released the documents that I sent you or not, or even if you sent them on to him, considering the fact that I received no email indicating that you had. As I stated previously, I am not willing to view the many continued attempts to silence me and harass me publicly. Well, that's okay, Anne, because apparently thousands of other people have. Can you please let me know where I can find your public record of this matter? I understand that my complaint is not appealable. I imagine that it must be nice to have the power to write a short message to end an issue and then move on without thought. I admit I am a bit envious of that power, as I have been dealing with the extremities of this matter for years with almost no power at all. From my perspective, it is very unfortunate that your organization apparently does not have the ethical standards to support victims being silenced and harassed online. So now, not only am I unethical, the Bar Association is unethical too, according to Anne. And that due to Mr. RFM's unethical actions, you consequently add your power to the offender's power. My opinion doesn't represent everyone's, of course, and it certainly doesn't represent Mr. RFM's followers or the typical men of Mormonism. But from where I sit, Mr. RFM's continued decisions to podcast about these matters do not reflect positively upon the Washington State Bar Association. Your decision to condone his behaviors is also recorded publicly. As I am sure you must be aware from outside of Utah, his behavior to many appears very unwell, and your actions and organization support it. Again, please let me know where I can find the public record of this matter. Regards, Anne McMullin Pfeffer. So that is the last filing in Anne McMullin Pfeffer's bar complaint against me. Oh, wait a second, it's not. There's something more, because the bar complaint wrote a letter back to Anne Pfeffer in response to this diatribe. And the title of this letter sent by the Washington State Bar Association to Anne Pfeffer is actually titled Letter to Grievant, RE, No Further Contact. It's dated June 13th, 2024. Now, that language does not appear in the letter itself, but when you title a document and then you save it and then you send it out, you can see what the title is of the document before you open it. And the title of this document is Letter to G, which stands for grievant. Letter to G, RE, No Further Contact. And that is the title of this document that the Bar Association sent to Anne Pfeffer. Here is the document itself. It is dated, as you can see, June 13th, 2024, and it reads as follows. Dear Anne McMullin Pfeffer, we received and reviewed your information dated May 28th, 2024 and June 6th, 2024. That's the information I've just reviewed with you. Under the Washington Supreme Court's rules for enforcement of lawyer conduct, disciplinary counsel may dismiss a grievance with or without investigation. You requested review of disciplinary counsel's decision to dismiss your grievance, and the decision was independently reviewed by a review committee of the disciplinary board. The review committee affirmed disciplinary counsel's dismissal of your grievance. The committee's order is not appealable. As this matter has been closed, we will take no further action at this time. If you submit additional information on this closed file, you should not expect to receive another communication from us. Sincerely, Courtney Lewis, Disciplinary Counsel, Intake. So this is the Bar Association telling Anne Pfeffer as nicely as possible, don't call us, we'll call you. If you have enjoyed this episode, please hit the like button. Also, please hit the subscribe button so you don't miss any future episodes. It also helps with the logarithm. So if you would hit the like button, hit the subscribe button. And I want to thank all of you who listen to this program. And a special thank you to those listeners who have gone the extra mile and made a donation to Radio Free Mormon by going to radiofreemormon.org and making a donation there. Your donations are keeping Radio Free Mormon broadcasting behind enemy lines. Well, that's about all for tonight. Until next time, this is Radio Free Mormon, signing off the air.